Well, good morning. This is Tampa Home Talk, and I'm your host, Katrina Madewell. Thanks for joining us, and hey, thanks for typing that music down there, Pat. Appreciate it. You know, I'm always losing my voice, and you're trying to make me yell over the intro music here. So welcome. This is Tampa Home Talk, and if you heard our 15-minute precursor segment, then you know today's show is all about how you hold title in real estate matters and talking about what that means to you. We're going to talk about some of the different ways to hold title, and we're going to dive into some stories and some scenarios, including one that we just experienced with one of our own clients. Of course, we never share names, but we do share the stories. And all of my clients pretty much know that because we talk about that before we even work together. So,
aren't we supposed to change the names to protect the innocent?
No, we're not going to be discussing any names. It's not the names that's important. It's the outcome that matters. So without further ado, I'm going to introduce our lovely guest for today's show. I have the honor and the privilege of working with him on a regular basis. Welcome, Mr. Perry Gruman.
Nice to be here. Thanks for having me.
And Perry's a long-time attorney. How long have you been hanging around practicing law in Tampa?
About 150 years. No, about...
feels like it, right?
It feels a long time, but about 35 years.
Okay. So he does a lot of stuff in the real estate, in the probate, in the, I guess life estate preparation. Is that fair?
Real estate, probate, bankruptcy, title matters.
Okay. So, which is why he's just stellar to talk about today's topic. And I can't wait to share the story. If you're listening to Tampa Home Talk, you're going to have to wait till closer to the end before we get it all out. And without further ado, we're going to roll on over to Adam Talley. He is our official insurance show partner for Tampa Home Talk. And what you got lined up for us today with our 2-minute insurance tip of the day?
Oh, good morning, Katrina, and thank you again for having me. A 2-minute tip of the day. With the holidays coming around, we have a lot of people that are trying to make a few extra bucks, either doing driving for Uber or Uber Eats, or there's a new app now that's called Toro where you can actually rent out your vehicle to other people.
Isn't there one where you can have alcohol delivered?
Yes, there is. That's Drizzly, which is also awesome. But when you do all of that, it changes how your auto insurance policy works, and not every carrier wants to insure you if you are doing deliveries or anything else like that, including simple pizza deliveries.
Does that make you commercial at that point?
It could. Not really. There are certain carriers that do it. You just need to talk to your agent and need to find somebody that knows what they're talking about when it comes to insuring you if you are going to do that stuff. Because if you get in an accident and your insurance carrier doesn't know about it, you could be set up for disaster there. So tip of the day is talk to your insurance agent before you go out and start doing those sort of things to make a few extra bucks. It's not going to cost you very much, but it will help you in the event that something happens.
Wow, I never thought about that. So basically you become almost like a commercial driver at that point.
You can, but usually you can find it on a personal lines policy. It's just only certain carriers want to do it. So like for Turo, for example, Safeco is really good when it comes to insuring you if you want to rent out your car. So that's just a normal policy. They just want to rate for it.
We talk about this kind of stuff all the time, and I'm just wondering, how do we get the whole stories if something like this happens and there's an issue and somebody's an Uber driver and they didn't tell their insurance? We have to talk to your underwriters about that? We got to invite them in? Is that how it works?
It'd be a claims adjuster sort of situation. Usually they're good about it, and we try to ask the questions. That's all it is asking questions before you write the policy. But, sometimes people don't tell you or they don't want to tell you because they don't want to know what the answer is. So we have found in the past, at least with Uber, they've been pretty good about taking care of their own. But, it's always one sticky situation away from something happening.
And again, if you got some questions, you want to get your insurance quoted out, as I was telling Perry, Adam just rewrote the policy in our building, and he saved us a lot of money in that renewal, and it was better coverage for less money. So what's your offering number? How can somebody reach you?
Oh, that is 813-685-9393 and ctalleyins.com.
What was that phone number?
Yeah, what was the number again? Sorry.
813-685-9393. Website is ctalleyins.com.
And it's 813...
685-9393.
Awesome. And if you ever need to connect with him on our offer number, we'll give you that number in just a few. Just text insurance, and we'll know you're looking for Adam. We'll get you guys connected. All right. And so without further ado, let's run into title. Now, if you heard the earlier part of the show, the intro, were you listening on the way in, Leo?
No, actually, I wasn't because the Avengers 4 trailer has just dropped 20 minutes ago. I watched it 3 times. That's why I'm running a little late this morning. And by the way, in case you haven't known, because we're on the radio, I can break news. The Avengers 4 trailer is out.
And when is it? Is it airing
You
Netflix
can go
now?
to YouTube, you can go to CNN's website, you can go, probably this station has it on their website.
But I mean, so the trailer's out, but the movie's not yet?
It was in April.
Okay.
was in
You're
April.
anxiously waiting?
Well, we got the Captain Marvel trailer this week, we got the Avengers today, and we're getting Spider-Man Homecoming tomorrow. And as a comic book enthusiast, I'm like on cloud 9.
Are you one of those Comic-Con people that dress up and I wouldn't recognize you?
I'd probably dress up and you would recognize me.
Oh, okay. All right. So, Leo, today's show is something that you would not normally see or deal with a lot, right? Since you do the insurance, the inspection part of it, you guys look really for defects and that sort of stuff. So Perry deals with like this snafu wildness you might have after the fact. And it's like a good real estate, Perry, and a real estate agent and a really good attorney. And I tell people, sometimes we get a bad rap, both of us, right? They don't like attorneys, they don't like agents. But I'll tell you, the thing with a real estate agent and with an attorney, especially a real estate attorney, you don't need them until you really need them. And then, if they try to do stuff on their own without somebody like me, you're going to bill them a lot more than I would right out of the gate to fix the mess. So, let's just run through in a nutshell the different ways to hold title, and then we'll go back and kind of re-explain what those mean. We'll give you stories, examples, and then, as I promised, during the 15-minute lead up to, we had a client that was able to close avoiding a $230,000 judgment, and we'll talk about that a little bit later in the show. So, what are some of the different ways you can hold title here in the state of Florida?
Okay, so there's several different ways. I'm going to talk about 6 of the most common ways. The first is the sole ownership, simply title to the real property is held in an individual person's name. James Smith owns title to a piece of real estate. The second is tenancy in common, and that's simply when there's 2 or more individuals that own the same piece of real estate. And the third would be similar to tenancy in common, joint tenancy with right of survivorship. Again, 2 or more persons own a single piece of real estate. And the fourth would be tenancy by the entireties. That's real estate owned by a married couple. Real estate can be held in Florida under a trust. And there's several different types of trusts, but the 2 most common that I would refer to would be a Florida land trust and an inter vivos trust, which is a trust established for the life of the person typically that makes the trust, and then for the benefit of typically family members upon death of the primary person. And then we can also talk about a ladybird deed, which is a type of life estate deed.
Okay. So we'll break down like what those mean in the scenario, which form of title might be the best one to hold when you're thinking about buying a property. And there's a bunch of interesting like scenarios, and it's one of those things you don't really think about it, right? Like we see it all the time when people, are buying a property. Very rarely do we even see the title company come back and say, hey, how would you like to hold title? I don't know why that is. I think they should, and there should be like an article from your underwriter pointing to what those mean, and then, of course, the title person doesn't want to explain it unless you're an attorney like you and your brother.
Right.
And then you can explain, what each of those means because they don't want to be liable.
That's a good point. Typically, the title company will rely on the contract to determine the identity of the buyer. But sometimes, we're typically dealing with contract forms, and they are not always filled in properly.
Right.
And there's ambiguity with that. So
As you know.
That's a good point.
So let's talk about the different ways to hold title and share like a quick little story or an example of what makes sense on the different ways to hold title. So number 1 is a sole person. And a lot of times on the deed, we will see a single man, a single woman. That's what you're talking about, that sole ownership, Barry?
Yes.
Okay. And so I guess a question after that, right? Because we'll talk about homestead a little bit later in the show and how all of that matters in the state of Florida as well. But when you think about sole ownership, Perry, you're buying a property, you're not married, you own it all by yourself. What implications could that person have? Does anything change if they get married? Like, those are some of the things that we should talk about when we come back right after the break. And our off-air number is 813-377-2775. If you want to connect with myself, Perry, Adam, Leo, 813-377-2775. And you can call or text. That number, you text any of our names, you need some real estate help, just hit it, our off-air number, 813-377-2775. And we'll be back right after this break in just a moment. Welcome back. This is Tampa Home Talk. I'm your host, Katrina Madewell. And in the studio today, we have Perry Gruman talking about how you hold title matter. In the title today, we're talking about the studio.
Quick off-air number.
813-377-2775. 813-377-2775. Hey, if you can't laugh at yourself.
The off-air number is a great stall tactic. You know it by heart. You just kind of, it's a mind reset.
Yeah, maybe. A little bit. We have a little too much fun sometimes in the break. I think that's what it is.
So sole ownership on title, is sole ownership like is that one person, or can a married couple have sole ownership?
Nope.
No, it has to be one person.
Perry? No.
So sole ownership implies one natural person.
Okay, because I'm one unit with my wife, or one entity, so I don't know.
But you don't own anything personally, right?
A chicken coop.
No, but you have properties. You just don't own them personally, right?
Well, that would be stupid to own property in your own name, I thought. That's what I've always been told. What do you think, Perry?
If we're talking about non-homestead property, I think that's a fair statement. You're better off holding property in either a trust, a land trust, or a corporate entity, or a limited liability company.
Okay, and that's, I guess we could talk about why in a little bit, but more often than not, we see, people either holding the title as an unmarried person, unmarried man, unmarried woman, or as, basically, is it joint tenants with right of survivorship, right, as husband and wife? When we see that on the deed, Perry?
In Florida, joint tenancy with right of survivorship typically is not husband and wife.
It's not. So which one does that fall under?
Joint tenancy with right of survivorship are two individuals. It's the same as tenants in common, but they have to have equal shares.
Tenants in common do?
Joint tenancy with right of survivorship.
Okay.
So you could have two people would each be 50-50, for example. Three people would be 30-30. And with joint tenancy with right of survivorship, of course, upon the death of either of the owners, that interest automatically vests in the surviving owners.
Which, if you have two partners that are just going to go in on something, there's been a lot of stories, right, over the case history over the years where people have killed people off, right, to be that right of survivorship.
Yes. And Florida actually has a statute that basically states that a killer cannot inherit property, and inherit includes acquiring property under a right of survivorship when there was a wrongful act.
I learn something every show. Don't you, Leo?
Yeah, no, that makes sense, and I feel better now if I had any of that type of ownership, knowing that if I get killed off, and then there's this CSI or Law and Order type investigation, that, well, then who gets the property? The state or the families?
Well, this is where a will kind of goes into play, right?
Your heirs would actually, if there was a wrongful act which removed you from the property, your heirs would step into your shoes.
Okay, so it's like that one commercial I saw where you think your company's in good hands, and then this 10-year-old takes over as the CEO when the CEO dies?
Exactly.
Okay.
So what about, we talked about if you put it in a land trust, and I've heard a lot of different opinions over the years, Perry, that say a Florida land trust is best. Do you agree with that? Or it depends on the scenario.
It depends on what your objectives are. Florida land trust has advantages and disadvantages compared to the other methods of holding title.
So what are the advantages?
Well, the big advantage of a Florida land trust is privacy.
Okay.
Meaning that the beneficial owners of the property, their identities are not a matter of public record.
Okay.
So with a Florida land trust, an individual or a entity acts as the trustee.
For example, an attorney would be the trustee, but the owner's identity would remain private.
Yes, and it would be like John Doe as trustee of the 123 Elm Street Land Trust. The deed would be recorded, and there would be no way to identify who the beneficiaries of that trust by just examining the public records. So from a privacy standpoint, a Florida land trust is a very good vehicle.
And so who would be a great example? Give me an example of who might be a good match for that type of
Real estate investor buying rental properties, for example.
Okay, and he's holding several properties in one trust?
Typically not. We would set up a separate land
Okay.
trust for each property.
Okay.
Right, and that would be because if there was a liability issue with respect to that property, by having separate land trusts, the liability would not spill
Right.
over onto the other property.
Plus, it would be a lot harder for an attorney suing to research who all owns what where, right?
Absolutely.
Where if you pull it up and there's just a big, long list in public records,
Right,
it's a little different.
right.
So I got a question from that standpoint. Does that mean that, like, let's say you own 5 properties, 5 land trusts, does that mean you have 5 tax returns?
Typically not, because now that will determine who the beneficiary of each land trust is. If it's the same beneficiary, then you would only have one tax return, and it would typically flow to your individual tax return, the income from those properties.
So I'm sorry. Even if you had different land trust names, it's still like one tax return gets created for all of those land trusts, and then that slides through like a Schedule K1 or something.
It's actually simpler than that typically.
Wow, that's good.
A Florida land trust generally is a non-taxable entity. The taxes are reported by the beneficiary on the beneficiary's tax return. So if the beneficiaries are the same for all the land trusts, it just flows to that beneficiary's tax return with respect to all of those parcels.
So those are the pros, what's the cons for holding it in Florida Land Trust?
One con would be that there's questionable liability protection with respect to a land trust, meaning that under Florida law, generally, the beneficiaries are deemed to be the owners of the property from a liability standpoint. So if there was negligence or failure to repair on behalf of the landlord...
Okay, so let's back up and break that down in a real story. Like, what might that sound like?
So you have an attorney that's a trustee
Okay.
under a land trust for a beneficiary who's an individual investor.
So beneficiary meaning the person that would normally own it. But now it's in Florida Land
Beneficiary
Trust.
would be the real estate investor.
That put the money up.
Exactly.
Okay.
So the roof caves in
Okay.
because the investor failed to repair it, and
Okay.
the tenant complained, there's a big hole in the roof, and it falls down and it hurts somebody.
Okay, then what?
The individual beneficiary under that trust, even though that beneficiary is not identified in the trust deed, is still individually responsible for that accident.
Okay.
So you don't have the same liability protection under a land trust that you do perhaps with respect to other entities.
So what would give you that liability protection? Which way to hold title would give you that?
Well, for example, a limited liability company could do that.
So holding title on a limited liability company versus a trust? With Florida Land Trust?
Yes.
Because there's a difference.
Yes.
Okay. So then it would, back to Leo's question, would require a tax return. Likely, right?
Okay, now
Maybe?
that gets a little more complicated. For a limited liability company, it depends what sort of tax treatment the limited liability company elects with the Internal Revenue Service.
So that's an easy
That's
fix.
a little more complicated, but you can set it up so that the taxes from the limited liability company similarly flow through to the tax return of the individual as well.
So let's say it's one property, 123 Main Street, one person, Adam Jones owns the property, and he's putting it in the 123 Main Street LLC
Yes.
entity. So what should he elect? Is there something he should elect if he doesn't really want to file a tax return? He's pretty much just doing that as a pass-through.
Well, if it's a single member LLC, then as a general rule, it would automatically flow to his individual tax return. So he wouldn't have to file any election with the IRS. It gets more complicated if it's a multi-member LLC.
Does it matter the number of members?
It does. If it's a multi-member LLC, the default election, without getting too complicated, but with the IRS, the default election is automatically that of a partnership. So then a K-1 would have to be issued at that point, but there would still be no double taxation.
So what I'm gathering is like there's tax repercussions for each of these different types of holding title, and then there's liability repercussions for each of these types of holding title, and then there's survivorship, like in case someone drops out. So it's like a triple whammy. You have to decide, and all the real estate investors I talk to, they just kind of like,
They don't think about it.
They don't think about it. They're just like, I need to get this property sold. I need to flip it. I need to own it as fast as possible. So
And that's the whole purpose of this show, is I think sometimes people want to jump in without thinking through not only the insurance, right, because the way you do insurance is different, but also the way you hold title.
this sounds very dangerous for a lot of the real estate investors I interact with on a day-to-day basis.
So let's talk about, because we're going to lead into the story of the one that we dealt with pretty recently, Perry, but let's say, for example, somebody buys a property and they, what would the common way they would hold it? Would it be joint or tenancy in common? Let's say it's two people, they're an investor, they bought 123 Main Street, tenants in common?
We're talking about a rental house, for example?
Yeah, rental house, yeah.
I mean, I would generally steer them...
I'm not, if they didn't have legal advice, and they just went into it, would probably be tenants in common?
Yes.
Okay, so in that scenario, let's just say there's two people.
Right.
And they got a loan, so it's in their name personally, right? Because we talked about that, and there's another whole set of rules on the mortgage with the lender. That's probably a different topic for another day. But let's say one of those people, Leo and I buy a property together. We're buying 123 Main Street. Now Leo has a judgment.
Awesome.
Leo has a
awesome.
judgment.
Up until you said I had
That's
judgment.
impossible.
So, all right, so we're going to talk about that scenario. What happens if all of a sudden somebody gets mad at Leo, he misses something on inspection, now
I don't like this story. Can we use a different story?
All right, we'll blame Adam.
Oh, goodness.
All right, you're listening to Tampa Home Talk. We'll be back in a minute. Welcome back. This is Tampa Home Talk, and hanging out in the studio today with Perry, Leo, and Adam. And it was funny because we were all sitting chatting with our headphones off during the break, and we heard the music. Oh, wait.
Oh, wait, you guys are next.
Cable.
You guys are next. I forgot to tell you.
Yeah, that's okay.
10
We
seconds
got
left.
it. We got it, Pat. Our off-air number is 813-377-2775, and you can call or text if any of this stuff is super intriguing you and you feel like you have something you need to ask Perry. Or maybe you need to get with Adam, or maybe you need to get with Leo before we list your property. You can call or text us at 813-377-2775, 813-377-2775.
Speaking of listings, since we're not going to announce any on the air, if you'd like to get a preview of our upcoming listings, go ahead and text listings to
813-377-2775. We'll give you properties that are not even yet on the market. So, before we skip past it too much, Adam, can you just talk real briefly? Because it's interesting. We were talking on the break saying, when you start adding in land trust and like LLCs and all this stuff, I would never recommend you ever buy, and even if you're paying cash, I wouldn't recommend that you buy a property without insurance at all. I think it's a huge risk.
100%.
Even if you're flipping it.
Liability at the minimum, for sure.
How does that play a role in insurance if it's a person versus an LLC or a Florida land trust?
Well, it all depends on actually how it's going to be used as well. So, for instance, if you're buying it in an LLC and you're just flipping it for a few months, there's a real specific policy that we can write for that. Super easy. That's probably the easiest thing that we can do.
What is that called, if I could ask?
As far as like the short-term policy,
Right.
There's a builder's risk out there, vacant property, that type of stuff.
Builder's risk kind of covers a lot of stuff. Like when we get these properties that are like not even financeable and there's a whole bunch of cash that's got to dump into it.
Yeah.
Like, I've got one listed now. It's a hoarder house. I mean, that's probably going to take a builder risk.
It's going to take something. When it comes to the LLCs, as far as rental properties, it really depends on the carrier that fits with it. The newer the house, the more likely every carrier is going to want to touch it. And then on the LLC, really, when it comes to the carriers, they want to look at the liability side. So we only have a few that will include the liability on there. And so if we had to do a separate liability policy, we could do that.
If there's tenants in the property,
If there's tenants in the property, of course. And then when it comes to the trust and that kind of stuff, especially if you're living in the house, that also takes a particular type of carrier to do it, because some of them are going to will write it in the name of the trust. Others will just list the trust as an additional insured and write it in the people's name, which obviously that might not go really well with the kind of protections you're trying to do in the first place with the trust.
The point of the show, like today, is ask a lot of questions. Like not only in advance when Leo is doing your inspection, but ask a lot of questions even before you get to the closing table. Absolutely. Ask a lot of questions about insurance. Tell the insurance person what you're trying to do, what your plan is with this property, short-term or long-term. That way you can make sure that you're adequately protected. And as you know, Perry Missouri, we're not an attorney state, so, attorneys are not required to close on a real estate transaction.
Correct.
And I would say most of them that close it are title companies. So with that in mind, there's a little bit of a gap. Like if your brother Eric were closing on a deal, he might notice something and say, we might want to change the title vesting, right? He could have a conversation.
Right, and that's problematic because when a title company does a closing, by law, they're not rendering legal advice typically.
That's what I was wondering.
So it's hard for him to provide legal advice even on an informal basis to one party but not the other,
Yeah.
for example.
It's got to be hard because I know, even back in the day, there's been a lot of times that I just did mobile closings or remote closings for other people. And knowing that I know how to read the documents was so hard for me sometimes to not say anything,
Right.
and just close the deal as a notary was just really hard because I knew, I know how to read arms and margins and, it's just, anyway.
You were a closing notary?
I did, yeah, I did. When I was pregnant with my son, I had a title company that paid me really well to close them, so I would just, if I had time, I'd go close it. Take me, less than an hour, and I knew all the documents. And
Right.
But, so going back to the title thing in the scenario that we said, let's say Leo and I are buying a property.
We don't like this scenario. Leo doesn't want to go
Okay,
to
so
jail. I love the part that we're owning property together. Don't get me wrong. Love that.
Okay, let's make it even better. So me,
Is
you
Leo
and Adam.
putting the money up? Or?
So all three of us. Let's say it's 33 and a third. There's three of us, right? Which can significantly change the dynamics. Three of us are going to buy a property and we decide, okay, the market's shifting a little bit in the next year, so we're going to actually just rent it as opposed to trying to flip it.
And I bought it using drug money, apparently.
Oh, God. That's a whole story in itself, Leo. Stop complicating it.
Can I pay for it in crypto?
We talked about that, too, a little while back. Anyway, so let's say we're buying this. We're all bringing some cash to the table. Maybe we get a small loan, which could be another whole issue in itself.
I'm definitely using Bitcoin paid for in cocaine sales.
This is getting complicated.
Oh, Leo.
That's why we'd call you, Perry.
I don't think I want to be involved in this transaction.
Thanks a lot now. You're killing my relationship. Thank you, Leo.
A flash drive can hold like $1 million in Bitcoin, which is now worth 70 cents apparently. And I'm using this for this Continue the story. We gotta make the story real.
All right, so seriously, we're buying this. We've got cash in all different places. We're getting a small loan, and now Adam made somebody mad, and he's got a judgment. And so this judgment, I don't know, let's say it's $60,000.
Right.
Property's only worth $250,000, but it's $60,000 plus it can accrue some interest.
And how did you buy the property?
I don't know. We just walked in the title company and bought it. How likely did we hold the title?
Probably in your three individual names as tenants in common.
Yeah, probably.
So that's not good.
Okay, so that's what we did, and now Adam's got a judgment. How is that going to affect us?
That's a real problem because that judgment will typically attach against Adam's undivided one-third interest.
Okay, so not Leo and my interest, but it would attach to Adam's third interest.
But that's a real problem because, for example, if the judgment is in an amount greater than his one-third share, then that's a lien against. It's only a lien against the undivided one-third interest, but it would effectively prevent you from transferring marketable title because you won't be able to pay that off at closing.
So let's say that judgment lien is now $100,000, and it's a lien on the property. Again, we're worth between $200,000 and $250,000. Can they make us sell the property? It's not a homestead property.
The judgment creditor can levy on the undivided one-third interest.
So they can force a sale. They can force Leo and I to sell as well.
Possibly.
Now, what happens to continue in this scenario, Adam's gotten in trouble and they find out that I paid for it in drug money using Bitcoin and the U.S. government steps in and seizes all my assets. What happens as we continue this bad scenario and Katrina made a couple of bad business decisions?
I'm going to refer you to a criminal lawyer at that point.
Katrina needs to make better friends, obviously, is the moral of the story here.
Oh, we love to keep this show fun, don't we? So, I mean, but see, that's the point, though. And when you start looking at homestead property in the state of Florida, you got a pretty big protection.
Yes.
And that's the difference. Like, so for example, I guess we'll lead up to it. The story that we had a while back, and I'll tell you the whole story in a few minutes, but it was a primary residence, homestead, owned by a husband and a wife. So if the judgment's $1 million, it doesn't matter, does it?
It doesn't matter under most circumstances. The one big exception is an IRS lien does attach against the property, even if it's only against one of the spouses.
Okay.
That's one big exception. But a general judgment creditor that lien would not attach against the property if it is only against the name of one of the spouses.
And am I correct in saying on a homestead property, they can never force a sale, even if it's an IRS lien? Really, they would never force a sale, would they?
If it's an IRS lien, if it's non-homestead property, they can and sometimes do force a sale.
Homestead.
If it's homestead, they legally can, but the general procedure has been they don't unless the district director of the IRS approves it, and they historically have not done that very often.
Yeah, I would say only in those, wild stories where someone's trying to 100% evade taxes, like one of these people. You don't have to pay taxes, it's not
Right.
legal. They tend to go after those people pretty aggressively.
Right, or if there's money laundering or that sort of thing, then they'll approve a homestead levy.
Okay.
Yeah.
So can you talk about a story where you had to, get in, post, someone already took title some way, and now they've got a real pickle, and they have to deal with it. Can you think of a story where you had to represent somebody and what happened?
Well, I mean, the common problem that we see on a recurring basis is that parties take title as tenants in common without putting the joint tenancy with right of survivorship language, which is just an added sentence that says with right of survivorship, and then one of the co-owners dies, and then a probate is necessary at that point.
Yeah.
And that's a big problem.
We had that scenario a little while back where two people bought it, weren't married. He was the one technically on the mortgage and the deed. Again, they weren't married, but they might as well have been married. He passed away, no will, and, now she's in the property. But technically, the kids could come after at that point, right?
Exactly. And then essentially you have a partnership or marriage between the kids and the surviving owner. And if, there's often bad blood, and usually it's about money at that point.
And these scenarios can get awful, right? When people die and there's money involved, like, people just get nasty.
I think family members are nastier sometimes among themselves than strangers.
Well, how easy would it be, like, let's say...
It's true, off, yeah.
How easy it is to fix a loan of these? Like, let's say we did a tenancy in common, but we want to switch it to tenancy with right of survivorship. How difficult is that?
That's relatively simple. You would simply just do a quitclaim deed, transferring it from tenancy in common, and then adding the joint tenancy with right of survivorship language in that deed. So that's fairly simple.
I'm going to add one little thing just because I can, and I know the nuances of everything that's in that mortgage. If you have a lien on the property, a mortgage lien, and you owe money to a lender, technically they have a due on sale clause, which means they don't want you to transfer or change anything, which is why sometimes, if you're buying a property personally, they don't want you to necessarily change the interest or ownership.
That's a good point.
Now, will they call it due? Probably not, like the IRS, right? Unless they have a reason to call it due, they probably won't. But do they have the right to? Absolutely.
So would they make you refinance at that point?
That's what a due on sale clause is. Due on sale means you sold the property, now the money is due. It effectively it balloons due pretty much.
Well, it gives the lender the right to call it.
That's right. Yeah, they have the right to call it. So let me ask another question with regards to homestead, since these things really matter. Let's say I own a property, and I own it personally, and it's my homestead property, but I don't want to actually have it in my name anymore. I want to put it in a trust or something like that, or an LLC. Have you seen where that affects the homestead exemption?
Yes. You can transfer it into a regular trust, typically not a land trust, but a regular trust. And if certain special language is added to the trust that the beneficiary of the trust intends to reside on the property as his or her primary residence and intends to retain the homestead benefit under the Florida Constitution, you can retain the tax homestead benefit as well as the forced sale homestead benefit.
Yeah, it can be a little bit messy and tricky, especially if it's a homestead property. I can't tell you how many times over the years I've seen people actually do a quitclaim deed on their own and create a cloud on title. We'll talk about that when we come back.
Good morning. Welcome back. You're listening to Tampa Home Talk and our off-air number, so you can get a hold of Katrina, myself, if you're more interested in learning how to, no, I can't do my really life example, or Adam for insurance. And this is just awesome. There's so many confusing questions out there with how to just arrange what names go into title, and it really starts with the real estate contract. It really starts with having the proper real estate agent like Katrina helping you, if you're an investor, just know what name to put on the document.
Well, here's the thing. It's not even about the names. You know how many weird things we see? And one of the advantages I work with Perry and a lot of attorneys just like him that are super sharp, they know what they're doing. We see kind of like the mess after the fact, and that helps you be a better agent and attorney today, right? So, for example, I went on a listing appointment yesterday, and they said, we want to list this property. It's about 6 acres, blah, blah, blah. So the first thing I do is pull it up, do a little bit of research. There's actually 3 parcels, not 1. It's 3. So from a legal perspective, and not I'm giving legal advice, but a legal description perspective on the contract, to make sure that alone is correct, that could create a huge cloud on title.
Right. Identifying the property to be conveyed is often screwed up.
Yeah,
So,
yeah.
yeah.
I mean, so these people do quitclaim deeds or other forms of transfer, and they try to do it on their own and save a few, because what is it, a couple $100 maybe to prepare the right paperwork and make sure you don't have to do that?
Right.
To go back and fix that, how many hours is that, Perry?
Too many.
It's a lot. It's going to cost you a lot more to fix that.
So on the front end, if Katrina, you're preparing my real estate contract, do you always check the box for your investors that say assignable? So you can make the contract assignable, so you can then, if they're putting it in their names to just get it under contract, they can then assign it to a land trust, an LLC or something?
It depends on the scenario. If I know that's what we're doing going into it, absolutely I'd make it assignable. I'll tell you that we get a lot of pushback from agents on either side when they see assignable.
Sellers don't like it either.
Well, because they don't know what they're getting into. They're getting into an agreement with you, and they've looked at your stuff, and then what if whoever you're assigning it to doesn't have good stuff, then it's not closing.
That's the way the wholesalers do it. They pick up a property, they assign it, they make it assignable, and then they sell that contract. They make a quick $5 or $10,000.
They do, and they can. But for example, if Perry's selling his house, let's say he's not an attorney that knows how to read the contract, and I represent him as a listing agent, I'm going to pick up on that. If I see it come through and it's marked assignable, then I'm going to ask why. Right?
Right.
Because, there's a good chance that deal could flop at the end. Now Perry's moved out. His whole life is packed. He's ready to move on, and downsize, and he's got an empty house, and we got to start over and find a different buyer.
Right.
It's probably a shifting market.
Right. And selling property to a flipper is more risky than selling it to a person that intends to retain that title.
Talk about that. Why?
Well, because typically the flipper will shop for a buyer between the time the contract's sold and the closing date, and if the flipper cannot find a buyer that's willing to pay the bump up or increased price, the flipper will back out at that point and then typically forfeit the deposit, which is usually low. $500, $1,000, and just walk away.
We don't take that. We're looking for at least 1% on our deals,
right.
At least.
But that way they tie up the property for 30, 60, 90 days for paying $500.
If they're paying cash, it's more. We're making them put a bigger escrow deposit down. They were going to have some skin in the game, so that kind of stuff usually weeds itself out. The problem that I have, and this is where you may or may not be comfortable with this as an attorney, Perry, but I know, we always look at public records to see how it's conveying. If that name is different, we're asking questions, because technically you can't sign a contract with a new buyer if you're not the owner.
Not exactly
Technically,
true.
well,
if you have a property under contract as a buyer, you can sign a contract to sell that property even though you haven't closed on it yet.
if it's assignable, or does it matter?
You could do it either way under most circumstances.
I think it's a little muddy, though, because you're not the owner.
You're not the owner, but you have a reasonable expectancy of becoming the owner. Now, I'm not saying I would recommend that.
Maybe if you saw the contract, I wouldn't have my name on that deal as an agent unless I had a lot more facts.
I see back-to-back closings all the time in some of the circles I run in. They'll close at 1 o'clock, and then they'll close at 2 o'clock with the new buyer.
A double close.
Double closing. They usually do that. The wholesalers will do that when they've taken advantage of a situation, pick up a property for $50,000, sell it for $75,000. They'll do a double closing so they don't see a $25,000 assignment fee on the HUD statement.
Yeah. So before we run out of time, Perry, I want to talk about the story that we saw. And I had a client that, have had about 3 deals with them before, so I've known them really well. And we were under contract to sell their property. And this part irritates me when people aren't totally transparent, just tell me everything, because I can probably avoid or figure out anything, but don't let something drop like a bomb on my lap right before closing, and that's what happened. So essentially, they own their property, husband and wife, married couple, homestead property, and the husband, we found out all the way at the end, when it was getting ready to close, had a $230,000 judgment. And the property was not even that much value that it was being sold for.
What was it titled, husband and wife?
Husband and wife, yep.
It was just a judgment against the husband?
A judgment only against the husband, and so what happened was the creditor was so aggressive.
Oh, that's... Now I know.
Yeah,
Okay.
now you know who it is.
Right.
The creditor was so aggressive that they bullied the title company was lined up with to close. They bullied the title company into not closing it. They pushed them so far that their underwriter said, sorry, we're not closing it, we're out of the deal. So, mind you, my client, which I represent the seller, is in Mexico. They've already pre-signed all their docs. They're ready to come back to a funded deal. And I had already flipped the deal over to Perry. And Perry basically, I explained the whole thing. He's like, no problem. Like him and I, within a matter of minutes, were able to kind of run through it and go, yep, judgment's not certified, which is another whole issue.
Right.
It only attaches to the husband. It doesn't apply to her. And this is a homestead property. That's good luck. They're not getting any money. So we were able to basically get that deal closed really quickly. And so what happened was when my client landed, I said, well, I've got good news and bad news. The bad news is your deal is not funded and you got to go back and re-sign a whole new package. The good news is we did a lot of work while you were out and it's ready to close. And then I told him the whole story about how, the creditor was aggressive, which by the way, I don't think I told you, but he called my office and was like,
You're not going to give me bad news here today.
No, there's no bad news, but you know as well as I do, he doesn't have a case. There's nothing, it doesn't stick to title, it's a homestead property, it wasn't an investment.
Right.
So, now going forward, that person may have some challenges, right, with how they hold property. They probably will never, because that judgment.
Exactly.
Because you can't go into it already having a judgment. That's going to sit.
Unless it's homestead, right?
All right,
There's
all
somebody
right.
at the door.
Yeah.
So the tip of the week is going to be pay attention to how you hold title. And if you don't know the different ways to hold title, and you really should ask, especially if you have heirs, if you're married, if you have family, because the last thing you want to do is get wrapped up in a probate. You deal with these, Perry.
I do.
It's probably a lot more fun to do the will in advance than it is to do the probate after, even though it's a lot more billable hours, right?
Absolutely.
So it's a lot of work, and it can be a mess. We can see families not talk to each other. So the tip of the day is going to be get your will, get your stuff in order, and make sure you pay attention to how you hold title. Our off-air number is 813-377-2775. If you got a question, I know a lot of you do because you're on property, hit us up, call or text 813-377-2775. We'll get you connected to Perry, Leo, or Adam, or me, whoever you're looking for. Remember, wherever you live, we're going to fix it. Welcome home. Have a great weekend.